The envelope was still in my hand when my uncle said it. "The estate's been settled. You need to be out by Friday." I didn't cry. I didn't argue. I just looked at him standing in the doorway of the house my mother had lived in for 23 years, and I thought, he has no idea what I already know. Let me take you back to the beginning. My mother, Claire, passed away on a Tuesday in late October. Pancreatic cancer. She was 58 years old, and she fought it for 14 months with a kind of quiet dignity that made everyone around her feel ashamed of their own small complaints. I was 31. I had moved back to Kelowna from Vancouver 2 years earlier when she got the diagnosis, subletting my apartment, putting my career in marketing on pause, because there was no version of reality where I let my mother go through that alone. My father had left when I was 9. My mother never remarried. It was always just the two of us, and her brother, my uncle, Daniel, who appeared at holidays and sent birthday cards with $20 bills inside until I turned 18, after which the cards stopped entirely. Daniel was 54, recently divorced, and had recently relocated from Calgary back to the Okanagan, which he framed as a fresh start but which everyone who knew him understood as a retreat. He had a history with money specifically, a history of not having enough of it and not being especially honest about why. My mother knew this. She loved her brother, but she knew exactly who he was. Which is why, 2 months before she died, she asked me to sit with her at the kitchen table while her lawyer, a careful woman named Patricia, walked us both through her estate plan. My mother owned the house outright, no mortgage. She had bought it in 2001 and over the years had paid it down while also building a modest but real investment portfolio through her work as an occupational therapist. The house, by the time she passed, was valued at just under $900,000. Her total estate, including the investment accounts and a small TFSA, was worth approximately $1.2 million. She did not leave any of it to Daniel. What she did instead was something Patricia had suggested, and my mother had immediately understood. The house was placed into a trust, with me as the sole beneficiary. Her investment accounts had a direct beneficiary designation, also me. Her will, which was the public-facing document Daniel would eventually see, made reference to personal effects and a small cash bequest. It looked, if you only skimmed it, like she had left her estate somewhat open. Patricia had been very deliberate about this. She told my mother, with me sitting right there, if someone is looking for an opportunity, don't give them one until there isn't one left. My mother had squeezed my hand under the table. I remembered that squeeze every single day of what came next. Daniel arrived 4 days before my mother died. He drove from Calgary in his truck and showed up at the door with a duffel bag and a casserole he had clearly picked up from a grocery store deli counter, still in the plastic container. He was warm in the way that people are warm when they want something: big hugs, emotional speeches about family, sitting at my mother's bedside and holding her hand while tears ran down his face. I am not going to say his grief wasn't real. I genuinely don't know. What I do know is that grief and opportunism are not mutually exclusive. My mother passed on a Tuesday at 11, 14 inches the evening. I was holding her hand. Daniel was asleep on the couch downstairs. I sat with her for a long time before I called anyone. By Wednesday morning, Daniel had already started asking questions. He was subtle at first. He asked about the will. He asked if my mother had set everything up properly. He offered, generously, to help me navigate the probate process, because he had been through it with a friend and knew how complicated it could get. I thanked him and said Patricia had everything handled. Something shifted in his face when I said that. Just for a moment. He stayed through the funeral, which was on the Saturday. My mother's friends came, her colleagues, her neighbors, the women from her book club who had been bringing her soup and audiobooks for over a year. It was the kind of service that makes you understand, very concretely, that the person you lost was genuinely loved. Not just by you, by a whole ecosystem of people who had organized their lives slightly around hers. Daniel gave a eulogy. It was good, I cried. Afterward, at the reception, he pulled me aside. I've been thinking, he said, and I just want to make sure you're protected. Estates get messy. I've seen it happen. If you need someone to help manage things, someone who knows the family, I'm here. I appreciate that, I said, because the house, for instance, that's a big asset to be managing on your own. You might want to think about whether holding it makes sense or whether liquidating and investing the proceeds might be smarter, financially speaking. I looked at him. I'll think about it, I said. I did not think about it. I called Patricia the next morning. She had already been in contact with the Land Title and Survey Authority in BC to confirm the trust registration on the property. She had also flagged something that neither of us had anticipated. In the weeks before my mother's death, Someone had submitted an inquiry to the title office about the property specifically, about whether there were any encumbrances or trust designations on the file. The inquiry had come from a real estate lawyer in Kelowna. A name Patricia didn't recognize. She pulled the file. The inquiry had been submitted on behalf of a numbered company. A numbered company that, when she ran it through the BC registry, had been incorporated 3 weeks earlier. The director of that company was Daniel. I sat in Patricia's office, and I felt something go very still inside me. He had started planning this before my mother was even gone. Patricia was methodical. She laid out what we knew and what we didn't. The trust was properly registered, that was not in dispute. The property could not be sold without my consent and without the trustee's authorization. Whatever Daniel was planning, he was going to run directly into a wall he didn't know existed. So we wait, I said. We document, she said, and then we wait. I went home. I did not tell Daniel what I knew. I made dinner, and we watched television, and he talked about property values in the Okanagan and how it was really a seller's market right now, and I nodded and said it was interesting. 3 days later, he told me I needed to move out. He was less subtle by then. He came into the kitchen while I was having coffee, and he sat down across from me, and he folded his hands on the table, and he said, in a very reasonable voice, that he had been reviewing the estate documents. He had found a copy of the will in my mother's filing cabinet, and that as the surviving sibling, he had some concerns about the asset distribution. She would have wanted the family to be taken care of, he said. She did take care of her family, I said. She took care of me. You're young. You have your whole life ahead of you. The house it's a lot to manage. I've been talking to someone, and there's actually an offer on the table that I think is worth considering. A very fair offer. What kind of offer? He named a number. $840,000. It was low. The house was worth more. But more importantly, he had no legal standing to accept or solicit any offer at all. I'd need to think about that, I said. Of course, he said. And I want to be gentle here, I think it would be best for everyone if you started making arrangements to transition out of the property sooner rather than later. While things are still friendly, there it was. I looked at him across my mother's kitchen table, in my mother's kitchen, with my mother's coffee mug in my hands, and I said, I'll talk to my lawyer. He flinched, just slightly. I called Patricia from my car. She had already been tracking the numbered company. In the 2 weeks since my mother's death, it had entered into a preliminary agreement with a property developer in Kelowna, a company that built luxury lakefront condominiums. The agreement was contingent on acquiring the property. The proposed sale price in the developer's internal documents, which Patricia had obtained through a contact, was $1.1 million. Daniel's numbered company would pocket the difference. He was planning to forge the transfer documents. He had, in fact, already taken steps toward this. Patricia had been contacted by the notary. He had approached a notary who, to their enormous credit, had refused to proceed and had reached out to Patricia directly after finding her name on the original trust registration. The notary had documented everything: the visit, the documents Daniel had brought, the request to notarize a transfer that purported to carry my signature. My signature, which I had not given. He brought forged documents to a notary. I said, he did, Patricia said. What do we do? We let him get a little further, she said, and then we make sure he can't undo it. I went back into the house. I told Daniel I had spoken to my lawyer and was considering the offer. I said I might need another week. He was visibly relieved. He offered to make dinner. He made pasta. I ate it. I did not enjoy it, but I ate it. Over the next 10 days, Patricia worked with a fraud investigator she had used before, a former RCMP financial crimes officer who now ran a private practice. He documented the paper trail on the numbered company, the preliminary agreement with the developer, and a series of wire transfers Daniel had already initiated from an account he had set up in anticipation of the sale proceeds. He had transferred funds through 3 different accounts. The total amount moved in anticipation of the deal was just over $400,000 money he had borrowed against expected proceeds from a private lender who also didn't know the sale wasn't legitimate. Daniel had not just forged my signature. He had committed mortgage fraud, wire fraud, and had filed a fraudulent document with a federal registry. Patricia reported it to the RCMP's Financial Crimes Unit, and then she called me and told me the date and time of the closing. The developer's lawyer had scheduled the formal closing for a Thursday afternoon at 2 o'clock at a commercial law office in downtown Kelowna. Daniel would be there. His own lawyer would be there, a man who, Patricia had determined, may not have known the full picture of what his client had done, but who was about to find out. I wore my mother's pearl earrings. Just one strand. Simple ones she had bought herself when she got her first job and worn for 30 years. I walked into that conference room at 1, 58 inches the afternoon. Daniel was already seated. He was wearing a blazer I didn't recognize new, it looked like. He had a leather portfolio on the table in front of him. He was talking to his lawyer in a low voice, and when the door opened and I walked in with Patricia beside me, he stopped mid-sentence. The color left his face. "What is she doing here?" he said. Patricia set a folder on the table. "My client," she said, "is the sole beneficiary and effective owner of the property at this address, held in trust since October of last year. The trust was registered with the Land Title and Survey Authority in September, prior to her mother's death. The transfer documents you have brought to this closing carry a forged signature, which has been documented by the notary you approached on February the 3rd and corroborated by a forensic document examiner retained by our office." The developer's lawyer put down his pen. "Furthermore," Patricia continued, "the RCMP Financial Crimes Unit has been notified, and an investigation is already underway regarding the wire transfers conducted through your client's numbered company in anticipation of fraudulent sale proceeds." Daniel's lawyer turned to look at his client. "This closing," Patricia said, "is not proceeding." The room was very quiet. I looked at my uncle. He was gripping the edge of the table. His knuckles were pale. I thought about my mother at the kitchen table, squeezing my hand. I thought about Patricia saying, "Don't give them an opportunity until there isn't one left." I thought about 14 months of soup and audiobooks and book club women who showed up because my mother had made herself worth showing up for. I didn't say anything. I didn't need to. The developer's lawyer asked everyone to leave while he conferred with his own client. Daniel's lawyer asked for a recess. Patricia and I walked into the hallway, and she handed me a bottle of water from her bag, and I stood there under the fluorescent lights of a downtown Kelowna office building, and I thought, it's done. The RCMP executed a search warrant on Daniel's rental apartment that same afternoon. His numbered company was dissolved by court order within the month. The private lender he had borrowed against the expected proceeds came after him civilly. The developer filed their own complaint. Having lost time and money on a deal that had been fraudulent from the start, Daniel was charged with fraud over $5,000, forgery, and uttering a forged document. In Canada, fraud over $5,000 is an indictable offense. He is currently awaiting trial. The house is mine. It is sitting exactly where it has always been, at the end of a quiet street in Kelowna, with the garden my mother planted out front and the porch where we used to drink tea in the evenings when she was feeling well enough to sit outside. I went back there the evening after the closing. I sat on that porch for a long time. My mother had understood exactly who her brother was. She had understood it so clearly that she had built an entire legal structure around that understanding months before she died, with a calmness and a foresight that I still find hard to fully absorb. She had not been bitter about it. She had not been angry. She had just been practical, the way she was practical about everything, the way she packed her own hospital bag early, the way she wrote thank you notes the week she came home from her final round of treatment, the way she made sure I had the name and number of every person I might need after she was gone. She had left me a letter with Patricia. I got it the week after the closing. It said, among other things, "I didn't want you to have to fight, but I wanted to make sure that if you did, you already had everything you needed to win." I had. She had made sure of it. If you are in a situation where someone is trying to take what isn't theirs, especially in the chaos and grief that follows a loss, please talk to an estate lawyer before you do anything else. In Canada, assets held in trust do not go through probate and are significantly harder to challenge or fraudulently transfer. Beneficiary designations on registered accounts like TFSAs and RRSPs pass outside the will entirely. These are not complicated things to set up, but they matter enormously. My mother knew that. Patricia knew that. And now Daniel knows it too. I didn't scream in that conference room. I didn't have to. The paperwork said everything that needed to be said. My mother played chess while she still could. She just made sure I was holding all the pieces when the game actually started.